Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, and thank you for stopping by. All right, guys, what we're going to talk about tonight is something that would be so sweet. New York's law, the new laws that passed after Bruen, basically making the entire state of New York a sensitive place, completely in conflict of Bruen decision, it's actually potentially going to be at least put under an injunction here in the next couple of days. The lawyers from the Gun Owners of America have it in court. Everything I'm going to show you right now is linked in the description box below. Please send this one out because everything that we've been fighting about, what happens if Bruen gets ignored? What happens if New York does whatever it wants? This right here is what happens. Lawsuits start flowing, lawyers get involved, and the court has the opinion and the option to actually stop this in its tracks. The most recent laws passed, not pre-Bruen, post-Bruen. This is incredibly important because it dovetails in another video we did earlier this week all about the concealed carry permits and how they're having to go back and redo them for ones that were denied post-Bruen. All of this ties together, and that is what we're going to talk about. Let me know what you guys think in the comments field below. I'm going to say a quick word from our sponsor for this week's video is Arms Directory, and then we're going to hit it. I cannot wait to hear what you guys think about this one. Now, Arms Directory is a two-way friendly social network and marketplace of ideas. With social media at large censoring a majority of freedom, Arms Directory is a safe harbor of freedom for all of us in the 2A movement. You guys know what I'm talking about. They are the only 2A protected social network out there to post about your passion today. You're free to post your favorite freedom pics, view blog posts of the industry, find local events, and more. And make sure to join the LOA family group that I just made and follow me on Arms Directory. And I will see you over there. And thank you so much to Arms Directory for making the videos this week possible. All right, brothers and sisters, we've got to talk about New York because, oh, baby, this would be too sweet. Again, everything linked. Gun rights group asked judge to block New York gun ban in Times Square and other sensitive places. Now, if you guys are not aware, the sensitive places is the big crux of this whole problem. In the Bruen decision, Clarence Thomas came down and said, yeah, you can protect sensitive places, but you can't make every place a sensitive place. For example, schools, government buildings, things of that nature. Well, New York went the opposite direction, completely ignored what the Bruen decision stated, and made the entire city of New York essentially a sensitive place, in direct violation of the Bruen decision from the Supreme Court. Well, that didn't go over too well with the GOA. Check out what they did here. A Second Amendment advocacy group on Tuesday asked a federal judge to block a New York state law that bans the carry of firearms in certain sensitive locations, such as stadiums, hospitals, and Manhattan's Times Square. Again, they made everywhere a sensitive place, which is in conflict of Bruen. Check this out. The request was part of a lawsuit brought by the Gun Owners of America against a New York law enacted this summer in the wake of a landmark Supreme Court decision expanding the Second Amendment. Okay, it didn't expand the Second Amendment, it curtailed gun control. Very important distinction, we've covered it a lot. Expanding gun rights would be adding things in. Curtailing gun control would be, hey, you can't tell them they can't do that, which is what happened here in the Bruen case, against the state of New York. Now, the important thing here is this is not old legislation that they're talking about striking down or putting an injunction on. This is the new legislation that they passed in the summer in a hurry under Hochul's advisement because they didn't want to have concealed carry going throughout the city of New York City and New York State. This is the new one. This is not the old one, and this has profound implications should an injunction be put in place. In response to the Supreme Court's ruling, New York Governor Kathy Hochul, Democrat, on July 1 signed a law that criminalizes the concealed carry of guns in airports, houses of worship, Times Square, and other sensitive places, prompting a swift legal challenge. Now, that's what we talked about on this channel. Yeah, they're going to ignore it because they are right and we are wrong. It's quite obvious. Doesn't matter if the SCOTUS agrees or disagrees. They are obviously the ones that are clearly right because they are the lefties. They are the gun controllers. They have the ownership of all common sense. You guys know, of course, that is tongue-in-cheek, but that is the mentality, that is the ethos on the left around the gun controllers. The only way is their way, and if you disagree, it's your problem, not theirs. Particularly around the legislature and the governor who went ahead and signed a law that completely conflicted with the Bruen decision, and now it's in court again. We said it was going to happen, and that is what's happening right now. During a hearing in the case on Tuesday, a lawyer for the gun rights group told U.S. District Judge Glenn Sotheby that the Supreme Court meant for the sensitive location exception to apply only to a narrow group of places, which it did. Clarence Thomas made it explicitly clear. Quote, you know, government buildings, schools, but not all of these places like Times Square. It can't be a sensitive place. Attorney Stephen Stambouli said, quote, "It could be that Times Square is sensitive at certain times, but not all the time. For example, like New Year's Eve or something like that. But this is important because they're getting called on the carpet." Defending the law was James Thompson, a lawyer with the New York State Attorney General's office, who argued that New York's Concealed Carry Improvement Act is deeply rooted in American history. Again, going back to that deeply rooted in American history, the left seems to be really fixating on that, particularly around the gun control, around ghost guns, the lawsuits that we talked about in Florida where they cited 17th and 18th century discrimination against Catholics and then also Native Americans as reason that they can do it now. I'm not kidding. Look it up. It's in the archives of this channel about 2.5 weeks ago. This is crazy town, but that's what they're doing because it's in the roots of history. And here's the last piece of argument from New York State. He said the Supreme Court's ruling June decision in New York State Rifle and Pistol Association v. Bruen recognized that protecting people from guns in vulnerable places is presumptively lawful. That has nothing to do with sensitive places because it specifically said in the Bruen decision you can't make the entire island of Manhattan, Manhattan, a sensitive place. You just can't do it. But they did it anyway, and now they're in trouble. A ruling on the plaintiff's request for a preliminary injunction against the New York law is expected soon in the case. Yeah, it better hurry up because this law goes into effect September 1. Imagine, just for a moment, if this gets put in, it has an injunction put on it, it gets put on hold, or it just gets completely thrown out. All the constitutional carry applications, all the constitutional carry holders in New York City won't have the existing new sensitive places that they can't carry. No more you have to ask permission to go into a business or the business has to welcome you in. No more you can't go into public spaces. That entire law will be struck down. And that's incredibly important, and that is part of our fight. Let me know what you guys think in the comments field below, and I will see you tomorrow morning on the bullet points. I'm Braden. See you later.